Why Supreme Court nominations have become so critical. Hey, think about it. Let me ask a few questions. How did we get to the point where 5 judges on the Supreme Court can violate the God-given right to life for unborn children for 45 years?
Amen.
How did we get to the point where 1 circuit court judge can tell the president how to execute an immigration law passed by Congress? Do you remember Proposition 8 in California? How did we get to the point where 1 circuit court judge overrules the vote of 70% of the people of California? In Tennessee, we have one of the most conservative state legislatures in the country. But we can't pass a law to ban the innocent taking of unborn life. Why? Well, the pundits will say, claim that, well, even if we did pass something like a life and conception bill, the courts would just overturn it. And therefore, they don't even try. Now, does that sound like the people are in charge?
No.
Is our country a republic, or is it an oligarchy? The way we view judges today, we really are an oligarchy run by a few men in black. Unfortunately, today we've accepted the idea that the courts are the final authority in everything, and no one dare challenge those rulings. How did we lose our liberties like this? How did we get to the point where we consider the courts the ultimate authority? Well, if you look back in history, it actually started with an evolutionary mindset that crept into the legal system. Actually, before the 1850s, most lawyers were not trained in law schools. They were apprentices for other lawyers. Well, that started to change with with Harvard Law School and its good reputation, and then actually about the same time, Harvard President Charles Eliot and Harvard Law Dean Christopher Langdale, who both believed in Darwinian evolution, started to incorporate those Darwinian principles into their law school. This system rejected law as coming ultimately from God, as was taught by William Blackstone and accepted by our founding fathers. And they created a case method approach of teaching law. This case method required students to collect and study opinions written by judges in legal cases. And then from these cases, using human reason, generalized laws could be extracted. And this is in essence, train lawyers to practice progressive evolutionary law where the judges were the ultimate authority and not God. Oliver Wendell Holmes championed this view in the Supreme Court in the early 1900s. And this case method view has now permeated virtually every law school in America. So that when you study the Constitution today, you'll study what? This court case decided this, that court's case decided that, and it's all about what the judges said and not what the Constitution said. We no longer study the original intent of the Constitution, but what the judges have decided the Constitution says. And that's what we hear every day about the Constitution is an evolving, changing document. In other words, what the judges says evolves the Constitution into what we have today. We've accepted what former Chief Justice Charles Evan Hughes, who served from 1930 to 1941 on the Supreme Court, he advocated that the Constitution is what the judges say it is. And this same view has the philosophy that the courts are the ultimate authority and not the Constitution. So the reality is, if you approach the Constitution in this way, what Justice Hughes says is true. And so what does that make Supreme Court decisions? It makes them the supreme law of the land and not the Constitution. And unfortunately, that's where we are today. And it's no wonder, and also that makes the judiciary the strongest branch. And it's no wonder the left is screaming about a conservative judge, because the left has used the court system and not the legislatures where laws are supposed to be made, but they've used the court system to advance almost all of their liberal agenda. Because it's easy to find a liberal judge to rule in their favor, and if the philosophy is what the judges say goes, then they get their way. So, my question again is, was that the design of the Founding Fathers in the Constitution? As always go back to the Constitution and see what it says. Article 3 of the Constitution deals with the courts. You read that, it's a very small article, you will find nothing in there that gives the courts the final authority on anything. In fact, all you'll see is that the judge's sole job is to rule on cases as to law and fact. They're not supposed to make national policy or put laws of the land, which they do today. In Federalist 78, Hamilton demonstrated the design weakness of the judiciary. This is a quote, it's kind of long, but listen to it, it makes a lot of sense. He said, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be the least in capacity to annoy or injure them. The judiciary has no influence on either the sword or the purse, no direction either of the strength or the wealth of the society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm for the efficacy of its judgments. This simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond in comparison the weakest of the three departments of power. That it can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. It equally proves that though individual oppression may now and then proceed from the courts of justice, the general liberty of the people can never be endangered from that quarter. Well, you may look at that quote and go, well, Hamilton really got it wrong, right? Look at what's going on today. He got it wrong. Well, did he get it wrong, or do we have it wrong? My contention is we have it wrong today because, again, we've acquiesced to that philosophy that the courts are the strongest and most powerful branch, and we have to bow to whatever they say. The founders did not deny that the courts had the power of judicial review, but they never intended the courts to be the final authority. And that same Federalist Paper 78, Hamilton affirmed the courts could make judicial reviews of the laws of Congress, but he also affirmed that this did not make the judiciary superior to the Congress. He argued that all the branches of the government were subject to the constraints of the Constitution and that the people were the ultimate authority. So what did some of the other founders think? Well, you look at some of their quotes and you'll see that Madison agreed. He said, but the great objection drawn from the source to which the last arguments would lead us is that the legislator itself has no right to expound the Constitution, that whenever its meaning is doubtful, you must leave it to take its course until the judiciary is called upon to declare its meaning. I acknowledge in the ordinary course of government that the exposition of the laws and Constitution devolve upon the judiciary, but I beg to know upon what principle it can be contended that any one department draws from the Constitution greater powers than another, and marking out the limits of the powers of the separate departments. Jefferson also agreed. He said, you seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Each of the three departments has equally the right to decide for itself what its duty under the Constitution, without any regard to what the others may have decided for themselves under a similar question. In fact, in the case of Marbury versus Madison, which supposedly established judicial review, Jefferson, as president, ignored the court's rulings. In fact, the court wasn't even upset because Jefferson had that prerogative. In fact, the court even made it easy for Jefferson to ignore them through a technicality and let them get off the hook. because they knew he was going to ignore them anyway, and the court wanted to save face about it. We go a little bit further in history. When the courts made a ruling against President Jackson, Andrew Jackson, in Georgia versus Cherokee Nation, he stated, and he was talking to John Marshall, he stated, the court has made its ruling, now let them enforce it. And guess what? He ignored the ruling. He also said each public officer who takes an oath to support the Constitution swears that he will support it as he understands it, and not as it is understood by others. The authority of the Supreme Court must not, therefore, be permitted to control the Congress or the executive. You go a little further in history, and Lincoln agreed as well. He said, I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court. At the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by the decisions of the Supreme Court, the instant they are made, the people will have ceased to be their own rulers, having resigned their government into the hands of the eminent tribunal. Of course, Lincoln ignored the Dred Scott decision of the court, which said that slaves were property, and he issued the Emancipation Proclamation. So by design, by constitutional design, when Congress passes a bill, they are saying, we think this is constitutional. When the president signs a bill into law, he's saying, I think this is constitutional. If the courts go back and say, nah, we don't think it's constitutional, well, the president and Congress has the right to go back and review it, but then they are not duty bound to go by what the court says, especially when it's so egregious as the court has been doing in over the years. That's the design. Now, I'm not suggesting we just willy-nilly ignore the Supreme Court all the time, but in cases that are obvious violations of the Constitution and the principles of the Declaration, it's the duty of the executive and Congress and the state governments to protect the people by ignoring or overturning those rulings. Now, there are several congressional remedies that nobody knows about. I don't have time to talk about them in detail. But if you look at Article 3, Section 1, Congress has constitutional control over the courts, period. They can abolish all the courts except for the Supreme Court. Actually, they could boil it down to one guy in the Supreme Court if they wanted to. So they could abolish all the courts, so they could take action like that. Congress can get rid of bad judges. You know, the myth is that judges are there for life. No, read the Constitution. It says under good behavior. So Congress can impeach bad judges. And good behavior doesn't mean, oh, you have to murder somebody to be impeached. It means any number of things, including bad rulings of the court. And also, Congress can rule a particular subject off limits from the courts. That's in Article 2, Section 2. Again, read it. Don't have time to get into all of it. But beyond Congress, our state governments should also not acquiesce to unconstitutional rulings from the courts. We have a federal system of checks and balances, and part of that checks and balance is the state's sovereignty in ignoring anything the federal government does that exceeds their boundaries as shown in the Constitution. Of course, they're not doing it today. We're so far down the road where all three branches of the federal government are totally ignoring the Constitution and doing things they shouldn't be doing. Right. So that's going to be very difficult to get back to where we were. But the point is, the more that we, the people, understand that the courts are not the ultimate authority, the less they're going to be able to get away with the distortions of the Constitution. So we, the people, must act to elect governors and representatives and congressmen who will not bow to the courts when they're wrong. Questions, comments?
Okay, we do have Dr. Black. I'm going to bring him in now. Dr. Black.
Good job, Ray.
Yeah, thanks, Ray.